Hello, everyone. Welcome to the U.S. Immigration News. We've all seen the frightening headlines. Another Filipino detained at the airport, another green card holder pulled aside and taken into custody. It's enough to make anyone from Manila to Mindanao wonder what's going on at our ports of entry. Over the past 6 months, we've covered cases where Filipino permanent residents faced detention over decades-old convictions. But this latest story goes deeper. Imagine believing you're a U.S. citizen your whole life, only to find yourself in ICE custody, scrambling to prove the papers you thought were ironclad. That's precisely what happened to one Filipino mother, and today we're unpacking every twist in her case. In this video, we'll reveal how USCIS's latest practices and the Trump administration's hardline approach are putting so-called citizens at risk. Walk you through the surprising facts behind this mother's claim and lay out what you need to know if your own status could be questioned. If you like this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Over the spring of 2025, news broke that a Filipino woman who has long insisted she holds U.S. citizenship was detained by ICE. Reporters said her custody stemmed from a forgery conviction nearly 20 years ago for a mere $60 check. She paid the debt in full, yet when she arrived for her routine trip back home, she was stopped and taken into custody. The shockwaves hit Filipino communities nationwide, because this wasn't just any green card holder. She claims U.S. citizenship by birthright through her father's service in the Navy. Digging into the details, it becomes clear that birth abroad citizenship isn't automatic. U.S. law requires that a parent, not just any American, must have lived in the United States for at least 10 years prior to a child's birth, and that at least 5 of those years occurred after the parent turned 14. If a child is born to an unwed U.S. citizen father, there's an extra step: a signed written agreement by the father to support the child until adulthood. We don't know whether those residency years or that written promise were ever documented in her file, nor do we know if the authorities had records showing her father met those requirements. What we do know is that this woman spent years checking in with ICE every 12 months, starting around 2020, while she pursued her claim to U.S. citizenship. That process, allowed by ICE, kept her in the country despite an earlier removal order. Yet 5 years of annual check-ins is an awfully long time to prove citizenship. Typically, USCIS expects documentary proof up front: birth certificates, school records, tax returns showing your parents' U.S. residence, even proof of your father's naval service. If any piece is missing, say a gap in those 10 years of residency or lack of that written support agreement, your claim can be denied, and any prior status, green card or otherwise, can be revoked. Even more alarming, news reports suggest this isn't her first ICE encounter. During President Trump's first term, from 2016 to 2020, she was reportedly detained for 3 years, again over the same forgery charge. That alone raises questions about consistency and due process. Was she ever given a chance to produce the documents establishing her citizenship? Were the courts fully aware of her father's service and her birth circumstances? Under Trump's administration, we saw a push for aggressive removal even in borderline cases, and it appears that policy is still influencing enforcement today. Beyond the legal technicalities, consider the human cost. Her children, apparently US-born and automatic citizens, have been separated from their mother. Community advocates have asked why no waivers were ever granted, why no justice judge paused proceedings while her citizenship claim was resolved. ICE's own practice guidelines allow discretion for family unity, yet here we see a mother detained, a family torn apart, and years spent in limbo. So what can you learn from this? First, if you have any claim to citizenship, whether by parentage, by birth abroad, or any other route, gather every possible document now. That means certified birth certificates, your parents' passports and naturalization records, school and tax records, showing their US residence, military service papers, and any written support agreements. If you were born out of wedlock, make sure that signed affidavit from your father is in your file. Second, consult an immigration attorney at the first sign of trouble. Even minor discrepancies, like a missing page or a date mismatch, can trigger a denial of citizenship and a possible removal order. An experienced lawyer can file petitions for declaratory judgment of citizenship or a N-600 application and can press for confidential handling of sensitive records. Third, green card holders should think twice before traveling without a rock-solid status. As we've seen, a forgery conviction or another petty offence can be used as a basis to detain and even deport. Under the so-called petty offence exception, crimes punishable by a year or less, and actual sentences under 6 months, shouldn't count as deportable offences. But if that exception isn't properly applied, even a small conviction becomes a removal trigger. Finally, stay informed. Follow USCIS and ICE policy updates, subscribe to advocacy group alerts, and participate in community forums. When enforcement becomes more aggressive, knowledge is your best defense. That's all we have in this bulletin. The US Immigration Updates channel provides all necessary visa information and procedures for your US immigration journey. We will continue to provide all information about US visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the US Immigration Updates channel. Thank you for watching, and we'll see you in the next video.